Yes, my lord, may I be permitted to mention one Jalpaiguri circuit in matter anticipatory bail, my lord.
Why now?
My lord, the matter has been filed before the vacation bench. Subsequently, it has been transferred to the regular bench. The matter has been listed till 10th of in the Jalpaiguri circuit bench, my lord.
So it will
Now the
come
bench
when.
is not available, my lord.
All right. No mentioning of Jalpaiguri matters. Why? Impossible. There is definitely a GR number. Allowed.
May I have your lordship to mention a matter for correction, my lord?
Well, may I be permitted to mention what matter, my lord? Matter is
Sorry.
My lord, here, if
We'll consider it.
my lord, say, in connection with that. My lord, do I need to submit this?
We don't entertain your application today because this week we cannot give you hearing. Mention in February, then we will consider. Okay?
Lordship, my wife is in a life-threatening situation, and on 3 occasions I have mentioned in past credit also
It is in the list. Ma'am, listen.
He also didn't come.
It should come. It was there in the list, I think. We'll consider. We'll put it.
Pending for last 1 year.
Lordship, may I beg to mention, Lordship's condonation delay along with appeal. Lordship, the Lordship accused already, Lordship's reduced bail. Oh, Lordship, another appeal already disposed of. And all the accused Lordships are in Lordships released by these honorable court. Only one accused person.
Why this appeal was not heard along with that appeal?
Lordship, that time Lordships somehow misguided.
No, who will miss? Why the department will miss? All right.
No, Lordship, the appeal has been now filed, Lordship. The person, Lordship, through legal aid, the appeal has
Okay. Give it.
My lord, bail in connection with the appeal.
been grateful, Lordship.
Yes, call the list.
Item number 3, instead of the co-shared, it will be written as de facto and landlord and tenant.
Next. Four.
That second page, my lord, first paragraph, last line, Lordship has allowed it, but it has come down as, hence we are not inclined to grant anticipatory.
Not inclined with that thing. Next. Yes.
I had contacted by way of electronic mails, even personally. Initially, they reverted back saying that the subject matter pertains to the issue of cooperation. So we should contact them. Then a very detailed mail I had written. But I'm still awaiting instructions, Willard. I apologize, Willard, but then
Who is the person, officer concerned?
My lord, we were trying to contact the secretary because what
The
kindly sees the first mail.
Deputy Solicitor General contents the Ministry of Cooperation, contents electronic mail was sent to the Ministry of Cooperation to clarify the amount of deposits, to clarify the volume of unpaid deposits to the members of the cooperative society. Unfortunately, there is no response to the said mail.
Mails, my lord. I have
To the said mails.
Yes, my lord. I have written at least 8 mails.
Principal Secretary, Ministry of Cooperative, shall personally or through its representative access the court proceedings on virtual mode.
But the cooperative, my lord, this was sent to the Ministry of Agriculture. Because, my lord, we had cooperative, my lord, they had filed a report initially before the Honorable Coordinator that this has registered. Now, on the last occasion, it was my lord's pleasure to direct the Secretary, Agricultural Department, Ministry of Agriculture, I stand corrected. So, my lord, we were trying to contact them. We have sent mails to the Secretary, Department of Agriculture.
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 A report was filed by the Ministry of Cooperation that the details sought for is available with the Ministry of Agriculture. Deputy Solicitor General sent electronic mails to the Ministry of Agriculture, but the mails went unrepresented, unresponded. Learned additional public prosecutor also submits investigating agency has not been provided with necessary details to determine the volume of unpaid deposits.
To me, direction was that whether any other cases are pending against them. See, we have sent messages, paragraph, second paragraph. Some have given response, but we are still awaiting for some.
With regard to the number of unpaid deposits, he has written to various, he has written to other investigation agencies, and the response is awaited. Full stop.
My lord, the Ministry of Cooperation did not file a report that any amount is known to the Agricultural Department. They filed a report initially that whether this particular company was registered with them or not. They said, yes, it was registered. Then whether they can carry on any such, they can have any such terms and conditions, or that they will collect money, my lord. That also we said that we cannot do anything as far as Ministry of Cooperation is concerned, my lord. But my lord, why? I apologize, my lord, my throat is bad. Now, my lord, I had written a mail to the Department of Agriculture saying that this particular
Why did you write to Agriculture?
my lord, may I, my lord, I stand correct. I wrote a mail to the Department of Agriculture that this particular cooperative is dealing with farmers and they are collecting money from the farmers. So any cooperative which is dealing exclusively with farmers as its members, whether you maintain a record with regard to that, if any money is taken, what is the procedure, and the entire details we want. This is what I wrote very comprehensively in my mail, my lord, initially when they wrote back to me that this is not our department. So, my lord, on 6th, 7th and 9th, if my lord kindly goes through my mail, my lord will kindly find that I exclusively told them that this may be the reason. If it is not there, if my lord, I apologize for my lord's copy. Well, this was my understanding, Miller, so therefore I wrote very exclusively, Miller.
On the file is the correct June, na? May 24. 22nd May first order. 22nd May. না আমি কোনো কথা বলছি কি বলে দেবে তুমি করে তাহলে গেট করতে 18টা ডেট হলো
So they have given a reply saying that it relates to Ministry of
My lord,
Cooperation.
initially, on the 6th, when I sent, they sent that it. So then I explained the entire circumstances. My lord, will kindly see the first mail which came to us. My lord, this is the first mail. My lord, stick to that. The first mail is this one, where one liner came to me. If my lord kindly sees the bottom portion of the mail, millet. This was the first mail, millet, which we sent, and then they sent it is. Please contact the cooperative. Then I wrote this mail, and then it was followed up by my mail on the 11th also. And I specifically said, but my lord, what I am humbly submitting, millet, that millet, if my lord kindly may record, subject to my lord's pleasure, my lord, that this has not gone, but my lord will give me 1 more week's time. Because, my lord, maybe, my lord, the government departments take some time to realize things.
It will not, nothing will happen in 1 week. Why 1 week? Nothing will happen in 1 year.
My lord, let me try, my lord. I will, this time I will not fail, my lord.
No,
This
no,
time I will
you
not
try your way, let us try our way.
My lord, if 1 week's time is given, my lord.
Ministry of Cooperation and Agriculture are directed to submit reports with regard to the affairs of Messrs. Human Welfare Credit and Thrift Cooperative Society Limited, a multi-state cooperative society of farmers, with regard to its raising capital, with regard to its inviting, with regard to its right, with regard to the following issues. One, whether the cooperative society has right to raise capital from the farmers on the promise of returning, on the promise of higher returns, to amount of unpaid deposits. Full stop. Reports be filed by the adjourned date. Failing which, this court would be directed, would be constrained to direct the officers concerned to appear personally or through virtual.
Great.
Urgent date to go.
My lord is giving.
Adjourn 2 weeks.
2 weeks will cover 27th. My lord is not there on. My lord is not there on 27th. बोलो ना तुम्हें.
Report of the state is also kept on.
My lord,
Give
this
us
bench,
a comprehensive list of his.
this bench will not be sitting on 27th. But keeps in the first week of Feb.
10th of February.
Grateful. Well, interim order till that date?
Interim order is here.
Yes, 31st January.
28th February. All right.
Grateful, my friend.
I'm grateful, my lord.
Where's the power to institute audit of this company, of the cooperative society? State of West Bengal has the power to institute audit of the. Who has the power to do audit of multi-state cooperatives?
But I have to take instructions.
Please
my lord.
find out.
My lord, I'll
You're
take.
sure? Find out from the Cooperative Society, Multi-State Cooperative Societies Act, the power to undertake audit. If it is of the state auditor general, have an auditor and give it.
My lord. My lord, the lady is a married lady, had relation with me. Then subsequently, when I came to know she got married earlier, I refused, and now this case, both adult.
You are married.
My lord, I was married and I have availed talaq as well, my lord. As per my instruction, my lord.
Where is the
And
talaq?
after talaqnama, I have to fetch, my lord. I was not prepared with this document. And my lord,
It was adjourned whether the lady is ready and willing to marry the or not. That instruction.
He was a married lady at the time of cohabitation. Let us keep that open. Petitioner contents victim was a married lady at the time of cohabitation. Cohabitation was out of love and affection. He prays for anticipatory bail. Learned lawyer for state opposes the prayer. Learned lawyer for the victim lady contents. She has obtained talaq from her previous marriage. We have considered the materials on record. Petitioner cohabited with the victim when she was married to another man. Allegation that victim was induced to cohabit on the false promise of a marriage must be appreciated in this factual background. De facto complainant victim contents she has obtained talaq from her earlier husband. However, it is nobody's case that the talaq had been obtained prior to the cohabitation between parties. Under such circumstances, we are inclined to grant anticipatory bail subject to condition meet investigating officer once in a week or further.
Highly obliged.
Next.
section 69 of the BNS, my lord. Admittedly, there was a love relation. The relationship does not work, and the instant case was reached.
The BSF suppressing his first marriage, my lord, enter into another relation.
Correct?
Correct.
My lord, I don't have instruction regarding the first matter. Great.
National for the state.
My lord,
This,
my lord, I am.
this is the report.
My lord, defective complaint is present.
Lordship, I have the
Not till now not delivered, my lord.
Still not delivered, and he is not cooperating with the investigating officer being called.
He will have to come to my showroom to take the delivery. We will have to find the.
He called well the IO. He is
No,
not
my lord, there is
cooperating.
defective complaint present, till now, my lord, not delivered.
I have given him writing. You have the card there. Let him go today.
That showroom is shut down for the last 4 months.
Police station. Lordship gives a timely order, otherwise police will not act.
Lordship is giving.
Lordship.
Yes, Lord. Lordship. Your Lordship, kindly. That will be very helpful. So item number 14, the order to be served.
That's right. I am for the petitioner, Lordship. Lordship, charge under 126 to 233, 117 to.
Yes, when the victim will,
Lordship, this is the report. Lordship will kindly see the third page. Last paragraph. After consultation with the learned public prosecutor of the Aramba Court, it came to learn the trial has started.
Hmm.
On 21st June 2018, copies has been served. 30th August, charge frame. 2nd August, deposition of witness number 1, namely Haradon. He is the de facto complainant, Lordship.
who
He's-
was threatened?
Lordship, he was threatened and assaulted. Lordship, thereafter 29th and 28th, this occurrence took place. Previous night.
18-2.
Thereafter, fixed on 18-2.
We are keeping it after 18-2.
Lordship.
Let him depose.
Lordship.
Report is placed on record. Victim is scheduled to depose in the murder case on 18-2-2025. Gist of the accusation, gist of the allegation in the FIR is that the petitioners have threatened the victim
To withdraw the case
to
and
withdraw the
assaulted.
case. Threatened and assaulted the victim to withdraw the case. Under such circumstances, we adjourn the hearing of this case till 25th of February 2026.
Lordship.
Petitioners shall not enter the jurisdiction of Goghat Police Station.
Lordship.
That order is already there.
Lordship.
Victim shall depose in the murder case. Victim shall be given necessary police protection and shall depose in the murder case in the meantime.
Lordship.
Further report we file.
Lordship.
Next. Already there.
in-law. Petitioner number 3 is the mother-in-law. Petitioner 4 and 5 are the wives of the petitioner number 1 and 2. And 6 and 7 are the sons of the petitioner number 1.
Manna drafted the petition.
Yes.
Huh?
Yes, my lord. কেন? কি করেছিস রে? কি করেছিস?
From after marriage, out of wedlock, children are born. মাথা চুলকাচ্ছে।
From. My lord, the allegation is that she was married in the year 2018. She has a child, son,
Yes, now.
aged
Yes,
about
Mr. Chatterjee.
My husband passed away because of brain tumor, my lord, in 2024 January.
Hmm.
My lord, thereafter, all my lord, the
January 24.
lordships. My lord,
And these are in-laws.
These are in-laws, my lord. All the insurance claims of my husband, my lord, which came,
Hmm.
my lord, they, my lord, have taken that away. My lord, the entire money that was lying in my husband's and my joint account, my lord, they were administering, my lord, stupefying substances, and they, my lord, have got, my lord, checks and documents executed by me, whereby, my lord, the entire money they have, my lord, taken away. My lord, my entire jewelry they have taken away. Thereafter, they have thrown me out
What
of
we
the
are doing
house,
is,
and they have
Mrs.
forced
Bose,
me execute a conveyance.
if there are jewelry, let it be handed over to the de facto complainant.
My lord, that there is no allegation even in the FIR
Yes,
to
there
that
is
nature.
allegation.
Where?
There is an allegation.
Paragraphs mention specifically money, LIC, jewelry.
No, jewelry, what we are saying, money LIC, according to us, it is a contested issue. Because wife, mother, both are class 1 heirs. So both will either have 50% share, etc. We are not saying anything.
So
That
the
will be-
petition, they have admitted that, my lord.
What they have
My
admitted?
lord, the
Yes, we
difficulty
have-
is, my lord, today
What they have admitted?
they have admitted that the entire, my lord, benefits of insurance have, my lord, are parked in the, my lord, account of the mother-in-law to in its entirety.
Ah,
My lord, my difficulty is I am a widow with a 4-year-old
so
child.
you cannot
I have
help
no
me.
wherewithal, my
That
lord.
is not the criminal
But let
case.
them at least transfer the
No,
50% to me, my lord.
Whatever jewelry we'll get. We will not allow the criminal process to be utilized for deciding civil claims. No.
My lord, only one.
Then the jewelry then.
Jewelry, yes.
One thing may I indicate?
क्या पैसा देना? This go. Let them go to the domestic violence act. If this is the way in which you have partition, tell us. This is what is this? It's a partition suit. It's a partition suit between two heirs of a Hindu male, mother and widow. The criminal case under 498A for partition.
No, my lord. They have coerced me to execute a conveyances, my lord.
Forget convents. All these things ask for cancellation. Coerced you to issue convents, so we'll ask for cancellation here.
And my lord, they have coerced
She
me.
had appeared before the
Please,
ADSR.
Mr. Ganguly. So far as jewelry is concerned, that is pure Stridhon. That should be handed over. Remainder will be decided in the courts of trial or other appropriate proceedings. How can you have money divided like this?
My lord, only
We are
one.
keeping it on Friday. In the meantime, let steps be taken for recovery of jewelry.
My lord, only one thing may I indicate. The husband dies in January. She leaves in June. She files this complaint in October. My lord can understand during this 5 months, she was staying in her house.
We are not said anything.
Very
She says jewelry, so let them go. Search your premises, find out if there is jewelry, they will take the jewelry.
Would your lordship be kind enough to protect us? Because if
We will protect everything, but not protect you from removing jewelry.
no, we'll not. She has taken away everything.
Very
well.
good.
That's why let
her
them
give
come and do
it-
whatever they want.
Jewelry is seen. So far as the money in the account of the mother is also an heir to the claim.
No, my lord, that is not the case. The money came to my account. They forced me to transfer it to their
Very
account.
good. Your account, her account. The question is, she is a co-heir of the asset. Okay.
And my lord, the money that my husband.
Listen, 406 does not apply because it is from one co-sharer to another co-sharer. Both have equal right on the property.
That is one part. The other part is the money that was already there in my account along with my husband. Me and my husband, we had a joint account. There was also money in that. That also, my lord, they have got it transferred to their own account.
So let that account, whatever the police can do, can get it attached. That's not the purpose of arrest.
My lord, the IO has not done anything, my
So
lord, in the
that is
meantime.
an application for anticipatory bail is before us. Okay. Petitioner, we keep it on Friday. Petitioner contents, petitioner's content, they are in-laws of the victim lady, of de facto complainant lady. Her husband died in 2021. She left the
24.
24
January 24.
January 2024. She left the matrimonial home. Subsequently, she is raising various false claims against the in-laws to give up their claims on the death benefits, give up their claim on the LIC and other death and other assets of the deceased of her deceased husband. They pray for anticipatory bail. Learned lawyer for state and senior advocate for de facto complaint oppose the prayer. They contend that petitioners forced the de facto complainant to transfer money from her account as well as and has held back her Stridhon jewelry, her jewelry. In light of the aforesaid submission, we direct the investigating agency to take steps for recovery of Stridhon jewelry, if any. Petitioners shall cooperate with the investigating agency, subject to the aforesaid. Petitioners shall not be arrested in connection with this case for a period of 1 week or until further orders, whichever is early. Friday.
Friday.
Next week is from Islam.
1 week.
Very well. Interim order is still 1 week.
Interim order for 3 weeks.
I'm deep.
3 weeks or
Returnable next Monday.
Next.
Next.
Deep. Next.
Tuesday.
Tuesday. Very well. Very deep.
is the step
Injury.
step daughter-in-law and the stepdaughter. Husband, my lord, who is the father of these two petitioners, he was arrested. He has been granted bail.
Petitioners are the stepchildren.
My lord, step daughter-in-law and stepdaughter.
Step daughter-in-law and stepson.
Stepdaughter. Two is the stepdaughter.
Petitioner number one is the stepdaughter-in-law, and petitioner number two is the stepdaughter of the de facto complainant victim. Allegations against them are general and omnibus. Injury does not appear to be grave under such grievous or life-threatening. Under such circumstances, we are inclined to grant answer. Next.
Next time for the petition, two groups of work are working a particular place, and simple issue they have started a quarrel. Issue the who get the next contact and petitioner is a 65 years old the senior citizen.
Assault and fracture.
Petitioner is the 65 years senior citizen.
Statement of the injured.
My lord, page number 41, my lord.
This is Kuddush.
Kuddush, my lord.
What about the other accused? Your sons?
My lord,
Kuddush and sons. Kuddush and company assaulted.
Kuddush not is involved, my lord. Kuddush, 65 years old, my lord.
What happened to your sons? Where are your sons? Are they arrested?
Not
No, my lord.
Then
No one else.
petitioner is petitioner contends that he has been falsely implicated. He prays for anticipatory bail. Learn a lawyer for the state oppose the prayer. We have considered the materials on record. Dispute arose between petitioner and his sons on one hand and the victim on the other. Allegation of assault is general and omnibus. It is unclear whether petitioner general and omnibus. Under such circumstances, we are inclined to grant anticipatory bail to the petitioner.
Yes, my lord.
Next.
I beg to appear for
I am for the petitioner. On the 21st November 2021, petitioner de facto complainant lodged a complaint that with a promise to install mobile tower over his property, he was directed to pay some amount which he has deposited, but mobile tower has not been installed. Now, accordingly, a criminal case has been initiated under section 406, 467, 468,
We have
419.
considered the materials on record. Petitioner is a member of a gang which carries on cyber fraud by inducing individuals to part with money on the false promise of setting up 5G mobile tower. Custodial interrogation is necessary, and this is not a fit case to grant anticipatory bail. Next.
My lord, I am for the petitioner. Copy has not yet been served to the victim.
Victim. One.
Grateful.
26.
Please.
318 subsection 4, 316 subsection 2, that is 420 and 406. My lord, allegation is that I was the driver of the de facto complainant. My lord, he says that I suppressed my identity and thereafter I took the vehicle, and my lord, vehicle is. Now, my lord, the de facto complainant himself is the accused in this case. My lord, why I am saying, my lord, he is saying I have suppressed the identity. At the same time, he is saying he went to my mother and asked about me. My lord, we belong from the same place. So, my lord, he knows me for the last 5 years. My lord, there was a hire and purchase agreement my lord, he failed to, my lord, give that anything. Now, my lord, he hided the vehicle.
Contents that he
Lordship, in
is-
their ID, they have given us fake IDs. He has given us fake ID. The picture is of his, but the name and address is as of different person.
Petitioner contends that he is an employee of the de facto complainant. Allegation that he has secreted the vehicle is false. Criminal case was registered to shield the de facto complainant from his liability to pay higher charges, pay installments to the finance company he pays for ancillary pay. Learned lawyer for the state submit petitioner used fake document to obtain employment. We have considered the materials on record. Petitioner was employed as a driver of the vehicle. It is alleged in the FIR that the vehicle had been purchased under a hire purchase agreement. De facto complainant had defaulted to make payments.
Nothing as such in the case ready. Nothing as such in the case
Nothing is
ready.
there.
Nothing as such
My
again.
lord, I have stated in my
Fact of
petition.
complainant.
So stating will not.
Not-
My lord, one thing, my lord, he says
Petitioner has secreted the vehicle, which is hypothecated to the finance company. Custodial interrogation for recovery of the vehicle is necessary, and this is not a fit case to grant answer. Next.
আমার 26 হলো।
This is my application.
Just for the state. Lordship have to intimate to the de facto. Section 74 is the no. Lordship, this is a report, your lordship. Hit by an iron rod all over the body, and nature is written simple.
We have considered the materials on record.
The main
We
thrust
have
of the
also
allegation.
considered the
Just statement is there.
whether injury is life-threatening, grievous or life-threatening may be assessed at the appropriate stage of the proceeding. Allegation of outraging modesty appears to be an exaggeration. Under such circumstances, we are inclined to grant answer. Take subject to condition. Meet investigating officer once in a week until further orders. Next.
Please, the Lordship, I am for the petition.
My case under the Electricity Act,
My lord, 135.
pilferage, my lord, theft of electricity by bypassing the
50%, Mr. Ray.
yes, man. Final assessment.
We are keeping it after 1 week. Petitioner undertakes to deposit 50% of the bill for unmetered final bill for unmetered consumption to the tune of
Madam,
so and so.
1,27,000.
Matter is adjourned 1 week. Next.
Wait, okay.
My lord, I am for the petitioner. 109, read with section 115, 117. My lord, here, my lord,
Nature of
inflicted blow.
Yes.
21, 22, 23.
22, 23.
And in
Comma,
statement, my lord,
fiscal
6, 9, 10.
Huh?
161, my lord, and this is
We have considered the materials on record, including the injury reports. Injuries were inflicted through fist and blows and brickbats. They do not appear to be grievous. Under such circumstances, we are inclined to grant answer. Next.
Allegation under section 118 subclause 2 7635 of the BNS Act. And Lordship, there is a family dispute between the both neighbors, and for this reason, this incident occurred.
My lord, page 21 is the injury report.
We have considered the materials on record. There was family dispute between neighbors. Injuries do not appear to be grievous. Under such circumstances, we are inclined to grant it.
Yes.
That is what we saw.
Yes, yes.
21. Lacerated scalp injury. Prognosis guarded. Is it grievous or guarded?
Guarded.
Guarded. Next. Allow.
Lordship, I'm for the appellant. Lordship, twice I have prayed for the certified copy of the judgment, but they are unable to provide me with the judgment.
From where have you prayed? Where?
Lordship, I have instructions that that from Krishnanagar court they are unable to provide me for the certified copy of the judgment, Lordship.
That is not true. This this copy has to be certified as true. This judgment copy has to be stamped certified.
Certified to be true. Lordship then grants me some
Appellant seeks further time to cure defect. 2 weeks. Adjourn 2 weeks.
grateful, Lordship.
Next.
No.
Next.
Well, for the applicant, my lord, I have served, my lord, this is abuse of service. Delay is 532 days, my lord. It is a legal matter, my lord.
I am appearing on behalf of the opposite party number 2. I am appearing on that state. 532 days delay.
532 days delay.
My lord, if your lordship kindly see, my lord, no proper explanation has been given, my lord. My lord, judgment was passed on 6th of January 2023. Applied for certified copy, my lord. After 1 year, 7th of January 2024, no explanation has been given.
All right. Appellant contends she was unaware of her right to prefer appeal against the order of acquittal. Subsequently, she approached the District Legal Services Authority. Subsequently, she was informed of her right to appeal and approached the Legal Services Authority to assist her in preferring the appeal. This has resulted in delay, this has caused a delay of 531 days in preferring the appeal. Learned lawyer for the state and opposite party number 2, learned lawyer for opposite party number 2 submit no explanation with regard to the delay has been given in the application for condonation. We have considered the materials on record. Victim is appellant is a victim of sexual offense. She contends that she was unaware of her right to prefer appeal against the order of acquittal. It may be pertinent to note that the impugned judgment that at the foothold at the in the impugned judgment, it may be pertinent to note in the impugned judgment there is no footnote that the victim had been intimated of her right to appeal. No order of acquittal was also sent to the victim. Will stop. In light of as per law declared in something. What is that Justice Topenshen's judgment that the acquittal order has to be communicated to the victim?
I apologize, I don't. No.
In light of the Mr. Mitra, what is that judgment of Justice Topenshen? Judgment, please give that citation. In such view of the matter, victim appellant was unaware of the judgment and order of acquittal. Later on, she was informed of her right to that she has a right to prefer appeal and approached the legal services authorities for legal to assist her in preferring the appeal. Prayers for condonation of delay. Now, in such cases, prayers for condonation of delay must not be viewed from a hyper-technical or pedantic manner, so as to deprive the victim of sexual offense of access to justice. Under such circumstances, we condone the delay in preferring the appeal appeal shall be, we have gone through the grounds of appeal. Appellant has made out an arguable case in appeal. Appeal shall be heard on merits. Appeal shall be heard. Appeal is admitted. Issue usual notice. Notice upon the appel upon opposite party number 2 is opposite party number 2 has entered appearance. Notice upon him is dispensed with. Within fortnight from date, he shall appear before the trial court, and on his appearance shall be released on bail to the satisfaction of the court till the disposal of the appeal. Lower court records be called for. Paper books be prepared within 8 weeks from receipt of lower court records. All right.
Yes.
Next.
Yes, my lord, I have been appointed by the High Court Legal Services Authority, my lord. Since the appeal has already been filed, I am filing the informal memo. 302, my lord, life imprisonment has been awarded.
Supplementary petition of appeal. Acha. Petition of appeal is placed on record. Appeal is admitted. Issue usual notices. Call for records. Liberty to pray for suspension of sentence upon notice. 8 weeks. Next.
কাগজ চিত্র দিলাম, কাগজ চিত্র দিলাম, দিলাম।
41. এটা কি legal aid Tina Mitra is learned lawyer empaneled by High Court is requested to represent the appellant. She shall matter is adjourned 4 weeks. Necessary steps be taken in the meantime. Next.
My lord, may it please your lordship, my lord, this is my application for admission under section 17 of the Fugitive Economic Offenders Act. My lord, the property, I am the bona fide purchaser. This has been confiscated. My lord, against that order, my lord, under section 17, my lord, I have come up,
Give notice to the respondent.
my lord.
For ED, Mr. Ajit Chakraborty is appearing. We have not received the copy yet.
I give a
I
copy.
tell you, admission,
Yes, Urgent 2 weeks.
of like. Lord, I'll serve only the memo.
You will serve everything.
My
My lord, I have the respondent number, my lord. This is the
Challenge.
For the state and for the de facto complainant.
Ishan,
So, the victim, the accused, and the court.
you are for whom?
my lord, accused person, my lord. Respondent 1, my lord.
Where is appellant?
Your Lordship, I am
State is the appellant, my
Oh,
lord.
state.
state is the appellant. Your Lordship, I am representing the de facto complainant, Your Lordship.
Huh. You are supporting.
There was a delay of 44 days.
Delay
actually.
condoned. Having considered averments in so and so, delay is condoned. Leave is granted to prepare appeal against judgment and order dated so and so. Now, if this is leave, may file the petition of appeal. Grounds of appeal. Next. How many days delay?
My lord, there was a delay of 393 days, my lord. My lord, this is the affidavit of service upon the accused who is a resident of Bihar. We have served by hand.
You are Bihar.
Yes, lordship. Oh.
Your Mokaratnama will be sent for verification.
Yes, lordship.
Here the agent is signing for accused from Bihar. What is the, on what ground the acquittal?
489B, 489C.
How long he was in custody?
My lord, within 3 years. But my lord, the problem, the basic ground that the land and trial court observed was that, my lord, although 100 pieces of FIC and 2000 denomination was recovered from the exclusive possession, it was the contention of the court that each and every such FICN was not marked. That was the principal ground. But the fact remains, my lord, in the Caesar list, all the serials were there, and the chemical report was produced in respect of each and every such serial numbered notes, which stated low quality fakes.
And lordship, there is a problem regarding GD number, lordship.
All right. We have considered the averments in the application for condonation of delay. Being satisfied, delay is condoned. Leave is granted to prefer appeal against judgment and order.
Lordship.
Next.
I gather Mr. Nondi is for the state. This is a restoration as well as the application for anticipatory.
For the defect.
Who? Rudro's mother is not well.
Oh, mother not well.
Day after tomorrow, he was saying.
Day after tomorrow.
Great.
Case diary is there. 400, 420.
Yes. Great.
Day after tomorrow. Next.
I'll be taking a 3 days time. I could not go through the brief.
46 days, come under the relaxation, but the paper book is ready.
Paper book is ready.
So that can be, but if your lordship kindly can be 3 days time, because I could not go through the brief. I was personally disturbed. My mother was not well. That is the reason, man.
Not this week.
I'm sorry, man.
Let the appeal, let this matter come under the heading hearing of appeal.
My lord is my lord, directing this matter to appear on the next week. Well, get.
My lord, I am for the petitioner, my lord. My lord, on the last occasion, your lordship has directed me to serve to file a supplementary affidavit, your lordship. And I have annexed all the orders and the reason, my lord. My lord, the petitioner is unable to furnish the bail bond, your lordship. He is a day labor.
So there was earlier. Supplementary affidavit is placed on record containing better particulars. Yes, now see what better particulars you have given. Better particulars. Why he showing his economic distress and inability to furnish bond, full stop. In light of the in paragraph 6 of the affidavit, it is stated that petitioner is the sole earning member of his family. He is a day laborer and sole earning member of his family. There are other members of his family are unemployed and dependent on him. Full stop. Under such circumstances, we are convinced that the financial condition of the petitioner is weak and he is unable to arrange for sureties. Hence, we register sureties. Huh?
My lord, it was registered surety. The bail bond is 10,000 each.
Oh. Hence, we direct that petitioner shall be released on bail on furnishing bond of 10,000. Oh, 10,000 is jaga. 2,000?
Grateful lordship. Grateful lordship.
Next. Forty-nine.
Malad, at the time of granting anticipated rebel, Malad, it was a direction by the Honorable Court that not to enter the jurisdiction while the victim resides. But the report says, Malad, several times he entered the
report is placed on record. Nobody appears for the petitioner, dismissed for default. 50.
50 for the petitioner. This is one of the affidavit of service that has been served upon the de facto complainant. The seat for application for permission to leave India to perform the usual Umrah for the period of the 15 days. And kindly allow me to file the supplementary affidavit whereby I have annexed the order passed by the learned magistrate granting the bail after the anticipatory bail.
Where do you want to go and what?
My paragraph 4 of the application, my lord, I have stated my itinerary. Kindly see paragraph 4.
Umrah in 90 days.
My lord, the paragraph 4, my lord, on 4th, my lord, I shall leave the India.
You deposit cash deposit, and any relation will stand as a surety. Who is there?
My lord, he will manage. My lord, kindly let me take.
Who is he will manage? We are giving direction.
My lord, nobody is there. My lord,
Nobody is there. We are not allowing him to go and.
My lord, after visa has been granted to perform the Umrah.
That is brilliant. You go, but someone has to stand as a surety that he will return after Umrah. Any family member is there?
In Arab.
In India.
Yeah, of course, of course.
Who is there? Tell us. Give the particulars of that name. Tomorrow we are keeping it.
Of course.
He will stand as an additional surety till you return. If you do not return, he goes into custody. Give the name of that person. Okay.
My lord, kindly, my lord, make it not today, my lord, I shall give the name. Not today.
Why in Arab? In India.
My lord, the affidavit of service be taken and the supplementary affidavit be taken on record, my lord.
Yes. 51.
Lordship, we are appearing in this matter, Lordship. This comes imprisonment, and out of 10 years, we have already suffered more than 6 years.
Kindly see page 21. His prayer has been turned down on 13th September 2021.
Thereafter 3 years have lapsed.
That is true.
Then what is the condition?
May I submit, my lord? The case is that 10 years conviction was granted. I am in custody for 6 years, all along in custody during the trial also. Now, if your lordship kindly peruses the depositions, my lord, it will be crystal clear that the allegation against me is that the girl was taken to the house that has been alleged to be a brothel, where she was ravished by one Jitendra, one of the appellant hearing. But my lord, no such document regarding the tenancy, regarding the any of the witness, nothing is there, my lord. No.
Yes, we keep this at 2 p.m.
My lord.
Lordship.
We'll hear out the appeal.
My lord.
Hear out the
In this matter, your lordship engage me from the legal aid for the appeal. Well, 2 p.m. I have a matter in page 434. So
34. So what?
So any problem, my lord, if I cannot present me.
You are for whom?
I have a matter in 434.
You are
from
here.
legal aid.
Legal aid cannot be a litigant. You are
For all, my lord, your lordship appoint me for all.
For all. Now they have. So if you can come, you come.
Yes,
Otherwise,
my-
we will make this.
Grateful,
2 p.m. 2 p.m. Go ahead. Get the paper book. Why you don't get the receive the paper? Ask them, make a photocopy. Keep it. Yes, 53, 54.
53 and 54, my lord, they are tagged together. In 53, the co-convict has been granted bail. I am in 54, my lord. I am in custody for 10 years, 7 months, and 24 days as of now. My lord, this is my renewal. The lordship had rejected in way back in 22. And so far as the co-accused has been granted bail, my lord, I am here 10 years, 8 months.
This one is 16 years.
My lord, I was granted bail during trial for 5 years. In total, pre-conviction and post-conviction, 10 years, 8 months. And he was not on bail. This is my
You are Raja.
my lord, Raja. My lord,
and Sheikh Shahid.
Raja and
Sheikh Shahid.
There is one appellant or two appellants?
Two.
1954, two appellants.
Same footing.
Same, all same, man. No, as Sheikh Shahid and Sheikh Raja. The eyewitness himself is the de facto complainant, but they are named. The offense is serious. And Kahar was also named, man. Not everybody is same. Offense is a very serious. Throat slit, stab injury on the eye.
Appellant is in custody for 4 years, 10 years.
10 years, 8 months.
Paper books are not ready and the appeal, paper books have not been prepared and appeal is not ready for hearing. Other convicts, that is appellants in CRA
27
of 2022 have been enlarged on bail. Accordingly, we are inclined to extend the same privilege to these appellants. Paper books be prepared. Lower court record, trial court records come. And trial court records be placed before this court within a fortnight.
Obliged.
8 weeks. 8 weeks. Paper books be prepared within 8 weeks. Next.
CJM Alipur. Obliged.
My lord, 55, my lord, I am for the applicant.
I am for the state.
My lord, out of 10, my lord, I am in custody for 5 years, 2 months, 12 days. NDPS.
Paper books ready?
No.
57.
What
is the quantity of narcotics?
24 kgs, 56 grams. I beg to appear for the 5 years loan.
I am appearing in 55.
I am appearing in 56 months.
All right.
I mean,
57 ta dao file that.
$55 ये बोलছে কেন? ও আচ্ছা।
কি বললাম 57 এর ফাইলটা ঠিক ভুল ফাইলটা দিল আর 2 পিন
Much. Stupid.